case of what's called forum shopping. I think that this is not the case of forum shopping. I think that what's happening here is there is an appeal, but that's not the same as forum shopping. And the question of who will ultimately interpret Jewish law, of course, now it's out of the hands of the rabbis, and now it's in the hands of the German authority. And that, I think, is a...
For the technicalities of implementing law, they have to go back again.
No, I don't think they do. I don't think they do. I think that's an exception. Now, in the case of the person who uses their influence, but I think the case of a monetary dispute can be decided by the courts. And the courts
personal status.
Personal status is different, but that's an exception, I think. I think that's an exception. The case of Jews who have a dispute and appeal to the non-Jewish authorities, that's not an exception. You can appeal outside the community. And there, they don't have to go back to the Jewish community. And that the use of Jewish law in a non-Jewish court, right? You can't do that in modern Israel. So.
But I think that's an important case, and we have discussed that already. There is probably, in general, in early modern legal history, too much talk about forum shopping and the benefits of forum shopping. I mean, as you pointed out, usually you are interested in a legal system that works not only once, but twice. Yeah? And this really should remind us that probably these cases should not be interpreted as exceptions. Yeah, some there are exceptions, and there are exceptional circumstances, but we obviously have here a body of court cases where both from the non-Jewish perspective and perhaps also from the Jewish perspective, this way of dealing with legal controversies was seen as the normal course of legal procedure, not as something exceptional. Yeah, because there are simply too many cases. Yeah. To be explained on the basis of forum shopping, just one exceptional individual trying to get the best deal. There are simply too many cases.
But this very development in the acceptance of the Jewish sources of law in praxis of the courts, maybe especially the
I think basically we have, we can't really, we don't have any results yet. Yeah? But I think there are two parallel developments that seem to develop in opposite directions. Yeah? On the one hand, there seems to be a greater familiarity with Jewish law. I mean, we have to remember that in the 18th century we have several universities where there are introductory courses to Jewish law being offered. Yeah?
Also in Nuremberg.
Also at
University of Nuremberg.
At Leipzig. Yeah, but there were no Jews, so I mean, this idea that Jewish law was a particular law and was also a valid law apparently gained in acceptance. At the same time, I think we have a countervailing tendency to restrict Jewish particular law, and that was a general trend. I mean, also say ecclesiastical law. I mean, the state tried to remove the church as a source of law and try to remove the guilds or other corporate entities that passed norms. So there is an interestingly, I think there are two parallel processes that go into two different directions. That probably also explains many of the ambivalences and contradictions that we have. Because one has the impression at the time that the state really cracks down on ecclesiastical law. Jewish law, in a sense, is still tolerated, and I mean, rabbinical jurisdiction is increasing in the 18th century. It's not limited. It's not getting limited, but it's increasing.